right, back on the record in the Simpson matter. Defendant's again present with his second set of attorneys. People are ready with their third set of attorneys. All right, there was one other discovery issue. Just as to the other two issues, the court anticipates issuing a written ruling regarding the Kelly issue, regarding the scope of cross-examination issue. And we had a discovery issue also to take up. And I anticipate filing that Monday. Both, as to both.
And before we finish, we can have some limited presentations in chambers in camera. There were some, at certain points in the argument, we made reference to things that we want to present to the court in that fashion.
Yes.
Should I proceed with the tape?
All right, let's go as to the discovery issues, however, first.
Your Honor, we have a number of concerns about discovery abuses with respect to a letter we sent you. The first issue has to do with the tape, which is the one that I think is most pressing because we believe it requires a hearing. The second issue has to do with the failure to provide certain laboratory pages, lab note pages, which we've been getting out of order really from the commencement of these proceedings, but we received a whole series of pages dealing with the chronology of events starting in June through July from Mr. Matheson in particular that we think we should have had a long time ago, and they impacted on things as distant as the split hearings and certainly related to other important matters. A significant issue that we would address for the court and is the late disclosure of these sets printouts and the APIMS printouts, which we think is a discovery violation. There is a very significant issue that we've been given, what is it, Mr. Police, 200, how many pages? 283 pages with respect to shoe evidence, memorandums from the FBI of investigations that took place in August, interviews from all across the country, things that if we were to double track at this point in time with the limited resources available in the middle of trial is extremely difficult. We should have received all that material much earlier. There is an issue that will arise, I'm not sure it's so pressing for today, that a bindle of hair and fiber that was removed from the hat, the Bundy hat, in Albany by Dr. Lee, and was sent back and received at the SID laboratory, was subsequently lost. Mr. Morton was unable to review that, and the prosecution has been unable to produce it. And we think that raises an Arizona versus Youngblood question, because that hat contained negroid hairs that were inconsistent with Mr. Simpson, which we think is potentially exculpatory evidence and would merit relief. With respect to the laboratory pages and the SETS documents, particularly the SETS documents, let me address that briefly. The problem there, Your Honor, is that we have been asking repeatedly from the very beginning of this case for all computerized records dealing with the chain of custody when these items were booked from the very beginning. We got property reports initially, then we got with dates that were all plainly inconsistent with the facts. Then we got a computerized printout a few months ago, maybe 5 or 6 months ago, that just indicated when things were officially booked. It took a long time to figure out what that meant. Apparently, it represented the date that things entered the APIMS system. I believe the APIMS system as opposed to the SETS system. As the court recalls, the SETS system is the computerized tracking system within SID. The APIMS system is the computerized tracking system that I guess covers the Los Angeles Police Department. um, we finally received, through the court's good offices and the efforts of Mr. Hodgman and Mr. Yokelson, I think about 2 weeks ago, or a week ago, really, a set of sets papers for certain key items that we specified because we wanted to get what we could get. But when you look at those items, what it represents is every time a package is taken from one area of the laboratory to another, people have to hit their barcodes. And then it indicates whether something is in transit,
Well,
where it
Counsel,
went.
I'm familiar with what it is. What's
Okay.
the problem?
The problem is that in order to figure out what happened to each item of evidence, one has to go back through the voluminous testing records and try to figure out what was being tested or handled at a particular time, because what they're tracking are, they'll put like 7 or 8 bags or a whole bunch of envelopes into one big box. Then somebody in the serology lab may go in at various different occasions and test certain things or not. And in order to figure out who had access and where it went and how is an extraordinarily complicated task. This is not a system that is set up as many others are in a sensible fashion, where you can have one set of documents, computerized or otherwise, to figure out who had what item at what time, when it was taken out, when it was tested, et cetera. This is a nightmare to try to track through their evidence. Now, we should have had these documents a long time ago so we could figure out what we were dealing with and track these through. And it's late disclosure, we feel, and frankly, we haven't had any meaningful disclosure as far as the APIMS records are concerned. They just handed us these huge, incomprehensible sheets of documents. It seems to us merits an instruction to the jury that the prosecution has failed in its discovery obligations with respect to these chain of custody documents. They were not turned over in a timely fashion, and that the jury can consider that with respect to what judgments they can make about whether chain of custody was properly complied with. And we'll submit that request to you in writing, a formal request for an instruction. But the most pressing matter is this videotape, which I understand the court has viewed. We have been asking for this videotape for months because a long time ago we saw on a television news clip a picture of somebody taking this videotape at Rockingham. In viewing this videotape, as I'm sure the court notes, there's a time on it that indicates when...
Date and time.
Date and time. We've been informed by the prosecutors, well, disregard that date and time, it's not correct. They failed to change the camera when they shifted over to new time period. But whether it's the daylight savings, whether it was the time that it purports to be on the camera, or whether it's discounted or moved ahead by an hour by virtue of daylight savings time. There are conflicts that we can see with respect to which people are seen at different locations and the documentation that we have in terms of when different searches were conducted. Perhaps most important of all, what does this videotape represent? We want to take testimony at a hearing from the people who made it as to what they were taping, who directed them to do the taping, what they thought they were taping. Were they taping the Rockingham residence and all the various different rooms as it was before any searches were conducted? What searches had been conducted before this tape was taken? Is this some kind of an inventory tape, or was this a tape that was taken to memorialize where various different pieces of evidence were? That's a question that we should have been able to explore at the suppression hearings in terms of the legality of the searches. This tape may suggest that searches were performed even before the search warrant issued. Or it goes to the nature in which the search was executed and the contentions about general search that were raised at that hearing. More importantly, for the upcoming collection witnesses, the location of various
Mr. Scheck,
items.
let me ask you this. Why do we need a hearing to do this? Why don't we just have the prosecution identify who the camera person was and make that person available for you to interview? I mean, why do I have to take up court time that I could otherwise use with the jury?
Well, we would like, Your Honor, well, first of all, I think that what we would want is that testimony under oath at this point, because we see contradictions. And we think serious issues. I'll give you a simple example. As I'm sure the court saw with great interest, at one point during the course of this videotape, the camera pans over the master bedroom and shows those straps that apparently were moved around at some point in time on the bed, and then just at the point where it's about to show the socks, a very critical piece of evidence in this case, and where they were at whatever time this tape was taken, the camera cuts all of a sudden and moves to a new position. We're very interested in why that happened. Also, the state of affairs in the bathroom and in other rooms, what was lying around, where it was, what knowledge these people have of that, that's something that we think should be taken under oath, that kind of testimony, so we can have that and use that on these issues.
Mr. Scheck, let me ask you this. Your letter to the court regarding this videotape was asking for sanctions, but you did not specify what sanctions you're seeking with regard to the late disclosure of the tape.
That's precisely the point. We don't know until we make inquiry of how this tape was created, who was leading around the person that was doing the tape, what instructions they had, what the circumstances of this were. We won't know what precisely the dimensions of the prejudice are, whether this tape helps us in certain areas as much as we think it might, whether or not it's something that the prosecution should be precluded from using parts or any of it. We don't really know. In order to figure out the dimensions of the prejudice here, we have to have a hearing, because it's very hard for us to figure out even the time that this tape was taken, much less the impact it has on search questions and also on the upcoming testimony of the witnesses who sees things at Rockingham. That's our problem, and we want that under oath. I mean, I'd like to accommodate the court in terms of the jury time. That's why I was perhaps inappropriately pressing the court to consider this issue yesterday. But we're very serious about this. We think this is a very serious discovery violation. I can point out to the court that there's panning of that garage area and the door, objects near that door. That's something that the defense should have known when it was cross-examining Detective Lang about pictures of that. It's something that the defense should have been able to see in cross-examining Detective Van Adder and others in the trial, Mr. Kalin, about that whole general area. What was the state of objects in that Rockingham address at a particular time is something that we were entitled to know at the suppression hearings and before this trial started. And we asked for this tape numerous times, and it was suppressed. The circumstances of why it wasn't turned over, I think, are also extremely relevant in terms of what sanctions the court might want to impose, and I think we need to have testimony as far as that's concerned. So
So you're asking for a hearing at this point?
That's exactly right.
All right. Ms. Lewis, is this your issue?
Your Honor, actually, Mr. Goldberg is going to address the court first to set forth the law and talk about the other documentary items. I'm going to deal with the videotape, so if you don't mind, we can take it in reverse order.
All right, let's do the videotape first.
Oh, you do want to take the videotape first?
Yeah.
All right. Your Honor, I had a conversation with Detective Looper of the Los Angeles Police Department yesterday, who was the detective responsible for the execution of the search warrant on June 13th at the defendant's residence at Rockingham. I believe Detectives Van Adder and Lang were downtown with Mr. Simpson during that period of time, and that's why he was responsible for it. That videotape, as Your Honor has seen, I guess, several times now, depicts the premises in and about the house very briefly, and all of the valuable items, including the many trophies and plaques and awards and so forth within the house, as well as the furniture, paintings, other items of value, and was taken as part of LAPD's ongoing policy to videotape locations where search warrants are executed. It's a policy that came into implementation, I'm informed, because of the 39th and Dalton lawsuits, which happened a few years ago, several years ago now. So that the policy of the police department is to take a videotape for their own civil liability, administrative purposes, to make sure that they don't have claims against them later that they've stolen property or they've trashed premises. That was the whole reason why this particular tape was taken. The tape shows the same locations that are shown in photographs. The defense has had photographs of the interior of Rockingham for months and months. Those photographs show almost the identical things that are shown on the videotape, except the emphasis with the videotape is on the value of various items, because it was taken with that purpose in mind.
So are you indicating to the court that this was taken by some LAPD photographer or videographer?
Yes, it was taken by, if the court recalls, there's a gentleman in a suit in there who I didn't recognize. He's apparently a supervisor from SID who was there, who came out with a, whatever you call somebody like that now, videographer, specifically for the purpose of capturing those things because of potential civil liability, which the Los Angeles Police Department occasionally experiences when it gets sued over matters having to do with the execution of search warrants. So that was an administrative tape taken for that reason, and it was a different, I'll just finish this sentence, I see you're about to inquire, but it was taken by a different person than the person who went through and did the photos. And it's also evident that this was an administratively taken videotape, itself authenticating in that respect because of importance. It does not show the blood in the foyer, the blood in the driveway, the pathway.
I think there are two, it does look down at what appears to me to be two of the blood spots in the foyer.
Okay, I missed
Two of
that.
the
I'm
blood
sorry if
spots,
it
right?
does.
And pauses it.
Yeah.
Well, I fast forward and rewound a little bit, so I didn't see that.
I watched it 4 times very carefully.
Well, I certainly trust Your Honor's perception then. But the point is, it did not go down the pathway. It was not meant to and did not record the scene as a crime scene. It did not record the most pertinent aspects of it.
Forgive me for interrupting you, Ms. Lewis, but the issue that I'm interested in is who took it, and why wasn't it turned over earlier than this week?
It was taken at Detective Looper's direction, as I mentioned. It was given to him the following day. He threw it in a drawer. Knowing that it was going to be for administrative purposes, it didn't occur to him to seek to make it part of the discovery type of materials in the case.
All right, let me ask you one other question. During some of the news coverage of the search at the Rockingham residence, long before I had any involvement in this case, I did see some news coverage in what I now recognize as the pool area, the wrought iron table out by the pool area, of a person that I recognized as a district attorney photographer who was carrying a full-size VHS camcorder.
The DA photographer did videotape the June 28th search.
Okay, perhaps that's what I saw.
I believe so, because I know this was an SID personnel on the 13th. And I believe the defense has had discovery on that June 28th
All right.
videotape. So what we're talking about here is something that was after Detective Looper threw it in his drawer. At some point after that, LAPD made available to the RHD an additional room to be set aside for this case alone. I was just going to give the court what happened to the tape after he threw it in his drawer.
Well, I'm just, Ms. Lewis, do you agree that perhaps the defense is entitled then to inquire of both Detective Looper and the videographer as to the facts and circumstances regarding both the creation of the tape and an explanation as to where it's been for the last 7 months?
I think that is a reasonable thing for them to do. We'll make Detective Looper available, assuming he's working tomorrow morning. It's Friday, I'm not sure, but we'll make him available tomorrow morning, and the same with the other person. They can speak to him. They're very forthright individuals. There's no reason to tie up this court's valuable time with a sequestered jury to have a hearing, some kind of a formal hearing on it. It's really not necessary, Your Honor. And the defense can easily satisfy their questions and their questioning with Detective Looper. And in fact, there's one aspect that Mr. Scheck didn't mention, but what we noticed about the videotape was a glove that shows up in the videotape more distinctly than it does in the photographs, and there's an explanation for that. They've not inquired about it, so I won't tell them. But Detective Looper certainly can tell them that, and I don't want to take up the court's time. I don't mean to be mysterious, but I've satisfied myself from looking at the videotape by asking Detective Looper certain questions about certain things I saw in there, and I think the defense can satisfy themselves more easily so, probably, by doing it informally with the detective and with the other person than in a formal court hearing.
All right. Mr. Scheck?
First of all, Your Honor, were we allowed to respond to the other items, the 8
Yes, you will. Let me just finish the videotape first, and let's get that out of the way. Mr. Scheck, the only thing I'm interested in from you at this point is why do you feel it's necessary to have a hearing under oath at this point if the prosecution is willing to make these people available to you first to interview? Because my suggestion to you is that I'm going to direct the prosecution to make them available to you tomorrow if they're on duty and available. And after taking statements from them, if you feel a further hearing is necessary with testimony under oath, I'll accommodate you then. But I'd like to do it the easy way first rather than having to, I don't want to necessarily use up my court time.
I think that the only problem is that we can't be at two places at the same time. And I suspect that the next witness is Mr. Fung. And we would like to know what these people are going to say about the circumstances of the tape. And if we had even learned about it any time earlier, we could have taken up the court's suggestion. The problem is that this is directly relevant to the testimony we're about to hear.
All right, well, let's do this then.
I would note one other thing, Joe.
Sure.
I'm informed that an employee at Mr. Simpson's residence testified at the 1538.5 hearing that she saw somebody there doing a videotape. So this was another reason that we've always maintained that there was such a tape, and I think they're on notice of it.
All right. Let's do this then. Let's order Detective Looper and the videographer here tomorrow morning at 8:30.
There's one other person too, Your Honor.
The most, I think, relevant person is the fellow in that interesting gray suit from SID.
With the badge hanging out
Yes,
of the...
yes.
Okay.
Who is?
You noticed that too.
I believe he's an SID supervisor. If he's, again, if these people are working tomorrow, we'll certainly
Okay.
have him.
How about if we have everybody here, those three persons involved here tomorrow morning at 8:30? Counsel be here at 8:30. We'll just have an informal interview. If you feel after inquiring of them that a formal hearing is necessary, I'll entertain it at that time. But I suspect, Mr. Goldberg, are you going to be handling the direct examination of Mr. Fung?
Yes, Your Honor.
And just out of curiosity, chronologically, where do you intend on starting your evidence collection saga?
It starts at Rockingham.
I was afraid of that. Okay. Well, I guess we need to resolve this issue first. All right, tomorrow morning at 8:30 with the three persons available.
Yes,
All right,
sir.
and Ms. Lewis, I give you leave to use the court phone right now, so let's make sure we get these people.
I'll do that in my room.
All right, thank you, counsel. All right, Mr. Goldberg, as to the APIMS sets, et cetera.
Your Honor, before getting directly into the facts regarding this APIMS and sets issue and also the other issue raised by counsel, which relates to these new L numbers of the laboratory reports, I just wanted to discuss general principles of California discovery law as we understand them now in a post-Proposition 115 environment, because I think that they will be helpful to the court in resolving not only these issues, but perhaps the issue about the videotape, as well as other discovery issues that are going to arise throughout these proceedings based upon the history of things that have gone on to date. First of all, the people's discovery obligation now, as I understand it, is limited to essentially two sources. Number one is the Constitution of the United States. We have to provide exculpatory materials, so-called Brady materials. And the second source is the Penal Code, 1054 of the California Penal Code. And therefore, in any discovery issue that is before a judge now in a post-Proposition 115 environment, there's essentially a two-stage analysis that the court must go through. One is to look at the issue of whether or not it is exculpatory within the meaning of Brady, and the second is then to go systematically through the penal code and mechanically apply what has been set down by the people of the state of California through the initiative process as the law of the state. Now, I'd like to address first this issue of what is exculpatory evidence and cite a couple cases to the court, which Your Honor is probably already familiar with in counsel. Don't worry, it's not the entire notebook here, but we'll do that later on this afternoon. But they do set forth a definition of exculpatory that I don't think we're really that familiar with here in California, because prior to Proposition 115, we basically did follow rules that were judicially created. And those discovery rules were essentially that we just had to turn over everything that we had in our case file unless it was somehow privileged. So the general rule is you give it over unless there's some specific reason why it is privileged. But that is not what the United States Constitution requires. And one case that discusses this is California versus Trombetta, the United States Supreme Court case that the court is familiar with at 104 Supreme Court Reporter, and I'm looking at page 2534. The court is probably familiar with this in the context of what we call in our state hitch motions, where a piece of evidence has been intentionally or negligently destroyed. But they also discuss discovery obligations, and they say that the definition of materiality for the purposes of determining what's discoverable is the same in the context of what we call a hitch motion as it is in the context of a Brady material. And what they said there is that whatever the duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. And then they have a footnote, and in a footnote 8, they say, in our prosecutorial disclosure cases, we have imposed a similar requirement of materiality. And we have rejected the notion that a prosecutor has a constitutional duty to routinely deliver his entire file to the defense counsel. We know of no constitutional requirement that the prosecution make a complete and detailed accounting to the defense of all police investigatory work on a case. So the Constitution does not require us to turn everything over. It does not require us to empty out our files, as was done in a pre-Proposition 115 environment. So we know that materiality does not mean you empty out your case file and give everything that's not privileged to the defense. In order to decide what it does mean, we have to continue on with some of the cases. And next, I call to the court's attention another fairly well-known United States Supreme Court case, U.S. versus Augers, at 96 Supreme Court Reporter 2392, and I'm looking at page 2400. There, the United States Supreme Court says, the Court of Appeals appears to have assumed that the prosecutor has a constitutional obligation to disclose any information that might affect the jury's verdict. That statement of a constitutional standard of materiality approaches the sporting theory of justice, which the court expressly rejected in Brady. For a jury's appraisal of a case might be affected by an improper or trivial consideration, as well as by evidence giving a rise to legitimate doubt on the issue of guilt.
One of my favorite judicial passages.
It's one of my favorite too now, Your Honor. If everything that might influence a jury must be disclosed, the only way a prosecutor could discharge his constitutional duty would be to allow complete discovery of his files as a matter of routine practice. Whether or not procedural rules authorizing such broad discovery might be desirable, the Constitution surely does not demand that much. They went on the same page, further on in another paragraph. The mere possibility that an item of undisclosed information might have helped the defense or might have affected the outcome of a trial does not establish materiality in the constitutional sense. So what we are essentially told in this case is we're talking about substantial evidence that might cause a reasonable objective fact finder to find a reasonable doubt. And that is the way it is also defined in California case law, where the court is probably familiar with the phrase substantial material evidence as being the sort of slogan that we use to describe what's discoverable. And in People versus Gonzalez at 179 Cal. 3rd 566, they talk about this standard of substantial material evidence in terms of evidence that's expected to play a significant role in the defense. And they say in that case, citing Trombetta puts it this way: whatever duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense, to meet the standard of constitutional materiality. And then they continue on further down in that same paragraph. In our prosecutorial disclosure cases, we have imposed a similar requirement of materiality and have rejected the notion that the prosecutor has a constitutional duty to routinely deliver his entire file over to defense counsel. So we basically know, based upon the federal and California cases, that when we're talking about materiality, we're talking about substantial material evidence of the kind that's expected to play a significant role in the defendant's defense, such that it would cause a reasonable or might cause a reasonable finder of fact, in other words, an objective finder of fact, to find a reasonable doubt. Now, as I understand it, the defense in this case is fairly straightforward in some ways. As I understand it, the defense is that Detective Furman planted the glove and then perhaps broke into the vehicle, the Bronco, and wiped the vehicle with the glove. Now, if that is the defense, does the defense believe that it's reasonably possible that he took the glove from Bundy, drove it to Parker Center, booked it into evidence so that it went through APIMS, then drove back out to the location at Rockingham to plant it, and then wipe it throughout the Bronco, and that if they only had the APIMS material, they're going to find some evidence of this? It is very difficult when you apply the standard of constitutional materiality to figure out how they can make a legitimate argument that this APIMS and SETS material falls within that definition. In order for the court to understand this, I'd just like to give you a little bit of background in terms of what these materials are.
Well, before you do that, Mr. Goldberg, isn't it correct, though, that the defense has already been given a set of each of these materials?
That's true.
So isn't the argument sort of moot? They've got it.
No,
The
because
question is how is it interpreted, or
Well,
whether or not there's any other way to.
they're asking us to reformat it. And see, this is one of the problems that we get into when, in my view, when we give them things that we are not required to do under the Constitution, that we're not required to do under the Penal Code. And I could turn to the Penal Code and also show how it doesn't come within any of the provisions of 1054. The problem that we get into is we think that we're being nice guys by jumping through all these hoops that they've set up for us. And every time that we've complied with these hoops, they always have a new hoop that they want us to go through. We thought, okay, we won't argue about the APIMS. We won't litigate it. We won't ask the court not to argue it. It doesn't come within the Constitution. It doesn't come within 1054. We'll be nice guys and we'll give it to them. We did the same thing with the SETS material. We decided that what we were going to do on the APIMS material was, rather than trying to decide what they might want and what they might not want, is just give them everything. So it is incredibly voluminous. And it includes the kind of computer codes, and I don't know the correct terminology for it, the encrypted type stuff that's used in a computer to generate the thing that you can read. It's in English. Maybe Your Honor knows what I'm talking about, because I'm just not familiar with the correct computer
No,
terminology.
if you recall, I've seen the printout that we're talking about.
Yeah, that's right.
Okay.
So they have everything. What they're saying is that the materials that they have are sorted out chronologically. They're not sorted out by item number.
All right,
So-
Mr. Goldberg, let me just jump ahead of you for a moment. Your argument is going to be is that your only obligation, even assuming that these are material, meet the test of materiality, your only obligation is to turn it over, not to interpret it for them, not to make it easier for them to understand, that your only obligation is to turn it over. Whether or not they understand it is up to them. Whether or not it makes any intelligible sense to anybody is up to them. It's not your obligation to sort it, explain it, and help them digest it. That's your argument, correct?
That's essentially it, Your Honor. Yes, that's correct.
All right. See, it's easy as a former prosecutor that I can sort of guess that that's where you're going.
Okay. Yes, that was where I was going, Your Honor.
I've heard that argument myself. All right.
But in this case, it happens to be correct.
I don't mean to interrupt you, but sensing where you're going,
Okay.
I thought I'd sort of jump ahead
No,
a few
I
steps.
appreciate that, Your Honor.
Okay.
And I don't know if the court wants me to continue, if you feel it would be helpful as to what exactly APIMs and sets are, because I think that it's been somewhat overbilled. They're not chain of custody type systems. What they do is they're something that would be used by someone who wanted to know where a piece of evidence was. So, for instance, if I were looking for the socks, item 13, and I had no idea where it was, where to start, I could, hopefully in APIMS, find that it had been, if it were sent out of LAPD and no longer in their custody, that it was in the court's custody. I could find that. That's the kind of information I could get through APIMS. But that would be it. I could also find out when it went into LAPD's custody, so it's sort of an in-out type thing.
All right, and for the court reporter's benefit, why don't you give us what the acronyms APIMS and SETS stands for?
Yeah, I wish I knew, Your Honor. You know, I've been practicing law for almost 10 years as prosecutor, and I had never heard of these systems until this case. I don't know whether maybe Your Honor had. I know that you have more experience in the judicial system than I do. And I've taken an informal poll and asked other prosecutors, and I don't think they've ever heard of it either, and I'd scarcely doubt that any defense attorneys prior to this case have heard of it, and that's why I have a lot of trouble with the idea that it is exculpatory material that would violate the defendant's due process rights if it wasn't turned over. I mean, everyone else has seemed to be able to litigate their cases and defend their clients without the benefit of this kind of material, except the defendant, Mr. Simpson.
Well, let me tell you what I foresee, though. I foresee cross-examination as to the chain of custody and integrity of the evidence during the testing process, and then asking the persons involved, primarily the criminalists from LAPD SID, to explain the chain of custody based upon these documents, which are probably unintelligible to the average human being.
Well, you know, I think the APIMS document is also unintelligible to the criminalists because it isn't the system that they use in-house. And what I was trying to find out about the SET system, since as I said, Your Honor, I really had never heard of it or even knew that such a system existed. So when I was trying to learn a little bit about it and how it worked, I learned that many of the criminalists don't know exactly how SETS works either. They know what they do to it and how they barcode things in, but they don't have a lot of understanding in terms of what happens to the information once it's in the computer. It's the kind of information that it really only serves one purpose, and that's if you're a criminalist and you want to know where within the laboratory I can find this box at any given time, because remember, it goes to boxes, not item numbers. You can use the SET system to do that. So I don't know how they could cross-examine them really effectively about something that they have very little knowledge about. What they need to do is the same thing that we did in this case.
But I suspect their whole goal is just to show that there's no coherent inventory system.
Well, but there is. And the coherent in inventory.
I'm just saying that that's going to be
right.
their goal. Whether or not that's true or not is for them to decide.
Yeah. Well, what the defense has to do is what anyone would have to have done before the advent of computers, and evidently this is reasonably new. I don't think that it's been around for 10 years or
Do you
anything
feel
like
comfortable,
that.
though, that I understand the prosecution position as to, now that you've turned over these computer printouts, that that's the end of your obligation?
Okay, thank you, Your Honor.
Okay.
I'll move on to the L numbers, if I might.
Sure.
This seems to be typical of many of the defense allegations of prosecutorial non-disclosures of information. in the sense that they don't give the court any specifics. They just say, we got a bunch of L numbers, new L numbers, and there's a discovery violation we want to sanction, without specifying what, if anything, is new, what's startling about these things, which one of these, if any, comes within the definition that we've just talked about in terms of exculpatory evidence or within the California Penal Code. Because again, we're turning over stuff that we really, in my view, in many instances, don't have any obligation to turn over. We've kind of taken the tact that is not required by the Constitution of emptying out our case files, and now they want to penalize us for doing this. What happened here, Your Honor, was with respect to a large number of these L numbers, Greg Matheson, who is one of the supervisors at the Scientific Investigations Division and also a witness in this case, was going through the materials that we've already turned over and recognized, as we had earlier on, that when L numbers were assigned initially, way back when, they were only assigned to the face page of a particular document, so that you might have a 12-page document with only the face page having L115, for example. And 116 would be a document that was 16 pages later, again being a face page. So in the interest of completeness and having some way of being able to prove, if we needed to, that the defense had a particular document, since they frequently come up to us and say, we never got this, and then we can go back to our records and prove that they did. What he did is he renumbered and reissued many of these pages that the defense already had. That reissuing was from page L579 to 715. So as to those items of these alleged 300-odd pages that the defense says or claims that they have that are new or previously unaccounted for, many of those I would assume fall into that category. As to the remainder of the items, according to what I have been able to determine, they are all relatively recent materials. And many of those materials dealt with records that were compiled itemizing the numbers before we sent them out to Albany for the defense inspection, itemizing them after they came back. There were notations as to the laboratory visit that occurred on Saturday. I believe that was the 3rd or the 4th of this month. There were many of these materials not falling with any of the provisions of the discovery law, which, as the court is familiar based upon our last discussions and the discussion of particularly Hines versus Superior Court, may include notes, but it would include notes of laboratory analysis, comparisons, observations, testing, and the like. And many of these things were chronological references to events that took place that have nothing to do with testing or analysis of evidence and the kinds of things that come within California case law that requires disclosure of certain notes under Proposition 115. So I think that the burden is really on the party that's making the allegation of discovery abuse to go through, to itemize the specific page numbers that they claim that they didn't have, and to try to articulate to the court what these are, why they're important, why there's been a discovery violation, so that the court has some basis upon which to make a decision on that issue. I'd just like briefly, I don't think the defense is asking for any relief on this right now, to mention the issue of the bindle of hair and fiber. I did not know anything about that issue until it was raised here, but what I can tell the court is that the procedure that the Los Angeles Police Department used is they photographed the evidence before it went out, and then photographed it after it came back. Of course, that's produced an enormous number of photographs, hundreds and hundreds of photographs, which the defense has. But that should be able to dispose of this kind of allegation. I'm not sure that the defense is asking for any form of relief on this at this time. Maybe they're just announcing it for whatever press value they feel it has. But I do believe that the court should summarily deny the defense claims of discovery abuses regarding the APIMs and set materials and also the new L numbers.
All right, what about the comment regarding the 283 pages of shoe evidence and reports from the FBI?
That was something that Ms. Lewis also looked into.
So I'll stand up and talk about that with the court's permission.
All right.
Your Honor, these materials are almost exclusively repetitive copies of a form letter, essentially, that was sent from the FBI, I believe, to various shoe manufacturers around the country. So it's correspondence, basically, and it's other types of memos and correspondence from this expert who we will be calling. But it's correspondence. It's not materials which are discoverable, as Mr. Goldberg has just talked about in terms of what materials are discoverable. These were things...
Mr. Bodziak's
Yes.
materials?
Yes.
All right.
And these were, he basically cleaned out his files. Mr. Goldberg alluded to us cleaning out case files. It's a similar analogy. He, after finally completing his reports, and I don't want to represent they're totally complete, because they may not be. But in terms of completing the reports that have been done to date and the analyses that have been done to date, those were the priority. That's what he sought to finish on and did. He got those out. And then he went far beyond what the defense even asked for in their recent letter which requested materials from Mr. Bodziak or Agent Bodziak. And that is correspondence and virtually everything he had in his files. So again, we turned over, as is my position as well, frankly, that we turned over materials which were not required under the discovery laws. And we have been especially forthright in this case from the beginning, and that was a decision made from the get-go to do that. But again, it's a similar situation where these are letters and correspondence and things that are not discoverable under the discovery laws that we turned over anyway. And so certainly we should not be sanctioned for turning over what we did not have to turn over. The defense should be grateful that they have received this information and early, before the expert testified. Your Honor, I want to mention that I did talk to Detective Looper. He'll be here at 8:30 in the morning. He's spoken with Mr. Ford, the one who actually did the videotape. He'll be here. We've not yet reached the supervisor because he's out doing something work-wise, so we should certainly be able to reach him as well. And it also occurred to me, back to the videotape for a moment, the blood on the carpeting would also be for liability purposes. That would be the reason why they would
This is blood.
videotape that.
Blood on the foyer.
On the foyer, whatever. It would be for liability purposes so that they couldn't later claim that the whatever material it is in the foyer or paint, I forget where this blood is, frankly, but so that it wouldn't have been something
No,
that the
it's just
LAPD damaged.
I think the argument is going to be, though, that what time, when, who was there when it was collected, and if it's still there at 2:30 in the afternoon or 3:30, depending on what time stamp
I have it
usually says.
through hearsay, because I didn't ask Detective Looper myself. I should have, that this was all done after the search warrant was executed, but we'll know that in the morning with certainty.
Okay. All right. Mr. Scheck, you want to tell me a little bit more about the bindle, the lost bindle?
Yeah. Mr. Hodgman and Mr. Yelkelson have been dealing with it. My understanding is that they actually have photographed the return of the bindle. So it was back here, and they, at this point in time, have lost it. So I think that's a pretty simple matter. With respect to the L notes, I think that Mr. Goldman's argument admits too much. First of all, the L notes were given to us out of order in the first place. In other words, we would get a crime scene checklist from Mr. Fung, and you'd find one page is L33 and the other one is 576. And that's the way we were receiving things in this case, and not great copies either. It is annoying because I wish I had a nickel for every time Ms. Clark got up and said everything was being turned over. But let's move on to the legal issue. United States versus Agers was overruled. United States versus Bagley is the law with respect to materiality. And the difference between Bagley and Agers on the issue of materiality is significant, because in Bagley, the court points out that materiality should be determined from the point of view of what the defense wants to do with something, some suppressed evidence, what its theory of the case is, what it needed at a particular time. It's no secret that the chain of custody documents that we are specifically asking for all along has been an essential element of the defense, as the court from its comments revealed. There is no excuse under the United States Constitution to continually refrain from turning over material that tracks the chain of custody of these documents and is relevant. It doesn't strike me as a particularly persuasive argument that the criminalists at SID have no idea how the system works when it's designed to assist them in tracking documents and creating a chain of custody. That argument, again, admits more than I think Mr. Goldberg intended. And it's for that very reason that these documents were in chaos to turn this over so late so that it becomes a nightmare for the defense to try to figure out which item was tested at what particular point in time and who had access to it is sandbagging. We've been asking for this for a long time.
All right, Mr. Scheck, let me bring some closure to our discussion then. First of all, as to the laboratory notes, the L notes that you're discussing, the fact that these were turned over to you at this point recently, and this comment also goes to the FBI notes regarding the shoes. What I think you need to do is present to me something that indicates that these items are material, that they should have been turned over, and that there's some prejudice to you from having not gotten them recently. Because if they are as represented, they sound relatively innocuous.
Hold on.
All right.
I mean, I tried to be specific. I'll tell you, I'll ask Mr. Blazer to address it. I'll put this in writing. But just so you know, I only addressed Mr. Matheson's chronology. Mr. Matheson testified as a witness in the split hearing. He, as you recall, had great difficulty remembering exactly what the discussions were on when evidence was going to be sent out for DNA testing and who did what and when.
Oh, I understand
Well,
that, counsel.
he created a chronology. He was doing a step-by-step chronology that wasn't turned over when he testified and wasn't turned over subsequently. It was only turned over last week. Plainly material, and I'll lay that out for you.
All right.
Mr. Blazer can address if you want now or if you want it in writing the issue of the shoes.
All right, both as to the lab pages and as to the shoes, I want that in writing. As to the lost bindle, let's have Mr. Hodgman look into that.
Yes, I've already started that, Your Honor.
All right. As to the videotape, we will start tomorrow morning at 8:30. I expect all interested parties to be here at 8:30. As to the APIMS and sets matters, I think I agree with Mr. Goldberg's position that the obligation of the prosecution is to make whatever is available, which they have done, and they have no further obligation to interpret or simplify.
Our position is when they made it available. Too late. That's the point.
Well, now you raise that issue.
No, I said that at the beginning. The point is not the APIMS records are unintelligible. Our point from the beginning is this. We have been asking from the beginning of this case for the chain of custody records, the computerized chain of custody
And they've
records.
given it to you. And if
Well, they
it's
gave it to us.
Mr. Scheck, if it's unintelligible, that sounds like a terrific thing to me, from your point of view, to cross-examine on.
No. The problem, particularly with the sets records, is that they refrained from giving it to us until I think about 3 weeks ago. Now, that is wrong. That is a violation of their discovery obligations. It is plainly relevant to our defense.
Mr. Scheck, your arguments to me have never mentioned that you're complaining about it, that you just got it. You're complaining about what it says and how you interpret it.
No.
This is the first time you're telling me.
No,
Yes.
Your Honor.
Yes.
Well,
Yes.
then I did not articulate it to you clearly enough. Let me be clear. My argument was it was turned over late, and the sets records, in conjunction with the other laboratory materials, require exhaustive cross-referencing. I think that's what I said. And by getting it late, we have been prejudiced because we still are trying to do that, and we shouldn't have that burden at this point in time. We should have had it months ago so we could further our investigation. That's the problem. To the court says, finally, we continue to be prejudiced by the prosecution's failure to produce in a timely fashion computerized records from SID and LAPD. That's the problem. Of course, it's an aggravating factor that they turned them over in the APIMS records.
So what remedy do you want?
I want an instruction. I want an instruction to the jury that the prosecution violated its discovery obligations by failing to turn over these chain of custody records in a timely fashion, and that they can consider that with respect to the credibility of the prosecution's witnesses on the issue of chain of custody.
All right, we'll stand in recess, 8:30.
One thing we need, very briefly, we still need to know the list of witnesses for the next 3 days, as per the court's initial order, especially now because there are different lawyers who are handling different witnesses and people are coming
All
from
right,
different
that's something
places.
that's supposed to be exchanged informally between the
Okay.
lawyers. All right.
Is the court's ruling on this, the 8 Henderson and Sets material still stand?
Yes.
Can we just ask the court's question about scheduling issues?
All right.
In terms of tomorrow, I think there were still issues that they wanted to raise. The defense said about the boards that we intended to use. I wanted to know when that was going to be brought up.
Bring them here at 8:30.
Okay, so the court wants to do that before the witnesses call.
Right.
All right.
That's the normal procedure.
That's why I would make sure.
All right.
Mr.
All right.
Simpson would like an opportunity to see the tape. May he stay here and use your equipment to view it?
We don't have it hooked up to the monitor right now. I excuse Ms. Fitzpatrick. She'll be here tomorrow morning. We'll show it to Mr. Simpson tomorrow morning at 8:30. 8:30 session is not open to the public. This is just informal discussions. We'll make that available. All right. Thank you, counsel. Where's Mr. Dart?